Okay, the whole point of using Prezi is to make it kind of, interactive and surprising for you guys, but you're gonna get the spoilers of click, click, click when I ask Kathy to move it along. So thanks for having me. Thank you, Kathy, Julia, Rochelle, for this really important conference. I will start with an overview of past and current consumer credit models. Click. Specifically, yes. We're going to go over 3 types of automated underwritings of consumer credit: traditional, alternative, and social credit. Click. So automated underwriting is relatively a recent innovation. In the past, most lending decisions were entrusted to individual loan officers and specialists who evaluated applicants on an individual basis. Then FICO, click, came into play with a mathematical formula that, when applied to information, can be used by lenders to determine financial creditworthiness. In 2006, the 3 major credit bureaus introduced VantageScore, another consumer credit scoring model. Click. Thank you. These traditional models, while closely guarded as trade secrets, have provided some information about the categories of risk that they consider. Click. Namely, that kind of ruins it, but let's roll with it. How you've handled credit, otherwise known as your payment credit history. Credit utilization, how long you've had credit, how much new credit you have, and what types of credit you have. Because the primary objective of credit score is to illustrate to lenders just how likely you are to repay your debts, credit history plays a significant role in the underwriting process. As a result, however, many who either do not have credit history or who have thin credit files become credit invisibles. Click. And were de facto excluded from the mainstream. Another click. Thank you. Yeah, those are the credit invisibles. And they were excluded from the mainstream credit system. And FICO has responded to the financial exclusion caused by its formula by adding factors like payment of utility and cable bills. And as of 2 weeks ago, click, a borrower's bank account balance and cash management behavior as supplements to its traditional credit score. However, this was kind of too little and too late because in the last decade, entrepreneurs have begun realizing the huge potential of the credit invisible market and began offering alternative credit and loans systems, which we call marketplace lenders. Click, thank you. Unlike FICO, which prides itself in not using data without meaningful correlation to a person's financial trustworthiness, these marketplace lenders have harnessed the power of big data for underwriting. So any kind of correlation basically comes in. Now, let's go over some quick examples, but before I'll do that, I'll just note that each marketplace lender has its own proprietary blend of data and analytics, which they treat as closely guarded trade secrets. So let's start with Zest Finance. That's the first one, thank you. Zest Finance is US-based, it's in LA. It's one of the pioneers in this alternative credit market. And they use thousands of variables, including financial information, technology usage, how quickly a user scrolls down the terms of service. And can you click? Click, thank you. So in 2014, in an interview with the New York Times, their CEO, Meryl Douglas, mentioned that people who fill the Zest Finance loan application in capital letters are riskier borrowers than those who write in upper and lowercase, and he says he doesn't know why. Now, another click for another click. Maybe try to close the thing at the bottom. Oh, we don't do secrets here. Thank you. Can you click one more time? And one more time, thank you. So that's from 2 months ago. Zest Finance entered a partnership agreement with Prestige Financial Services to implement the industry, let me quote, first fully explainable machine learning model. Did you know that? There is such a thing, apparently. So, I mean, this is big news by itself, but also it shows that it goes mainstream. You can click now, thanks. Lendoo, so unlike Zest Finance, which is US-based, Lendoo is in Singapore. And I was doing a lot of work on social credit, and they were one of the first companies to consider social network data in their analysis. And the kind of information they take into consideration is things as whether you avoid one-word subject line in your emails. Apparently, if you put more words, you are more details-oriented, thus lower risk. And whether you have financial apps on your phone and how often you check them. And I love this one, the ratio of selfies versus non-selfies on your phone. Because apparently, if you have a lot of front-facing camera pictures, they apparently indicate youth, which I don't know if it's a good thing in this context, but that's one of the things they take into consideration. So another click for Lendoo. So at the end of 2017, Lendoo merged with a scoring company, EFL, which stands for Entrepreneurial Finance Lab, and they use psychometric testing. So Cambridge Analytica for credit. Moving on. Yes, sorry. Yes, and that's actually, and another quick click, please, for Coremetrics, another one. Coremetrics is a UK-based company, and they use mostly psychometric information for evaluating credit decisions. Interestingly, in one of the articles where Coremetrics, I think it was CEO, was interviewing, they said something like, the US market is not culturally prepared for psychometric-based credit scores. I don't know about that, but that's definitely happening in the UK already. Moving on. Thank you. Another UK example, this is a very interesting example, student loans company, because that's the only public institution. It's a non-departmental public body company in the United Kingdom that provides student loans. And interestingly, you can see at the top, maybe another click. We can zoom in. No, sorry. Okay, you can leave that. They were criticized for using social networking information in their credit decisions for loans for students. And of course, we cannot talk about social credit without mentioning the 2016 patent that Facebook filed. Can you another click, please? Thank you. That's an actual quote from the patent application. In a fourth embodiment of the invention, the service provider is a lender. When an individual applies for a loan, the lender examines the credit ratings of members of the individual's social network who are connected to the individual through authorized nodes. If the average credit rating of these members is at least a minimum credit score, the lender continues to process the loan application. Otherwise, the loan application is rejected. And that's a real story. I'm not making this up. Okay, click. The third category that we're going to briefly talk about is the social or citizen credit. Click. Okay, so when I talk about social or citizen credit, it's not so much about financial trustworthiness as trustworthiness overall. So some of you probably know the famous Black Mirror episode where people are being rated based on their behavior. And actually, this model is already being rolled out in China. We know about the Chinese model. Can you click another one, please? A lot of information from various sources is being considered. And this credit score gives awards as access to certain products and services, but also penalties such as not being able to use certain types of public transportation, just like in the Black Mirror episode. Okay, and 2 days ago, you can click another one for me, thank you. We were introduced to the same idea in Venezuela. Apparently, there is a Chinese company, another click, please. a Chinese company that is helping implementing a similar system in Venezuela. That was a Reuters report from Wednesday. And another click to the big question, what about us? And us is literally the US in this slide. So what about us? We feel like we're kind of immune from those social credit trust systems, when in fact, I think both the examples that I showed in the marketplace lenders examples, but also what we're going to talk about now, show that we're not so far away from that. Click. Okay, back to Facebook. And I know some of you think that Facebook is dead, especially after the New York Times report from 2 days ago. They're not dead yet. And even if they will be, someone else will take it, I promise you. So Facebook filed a patent on this year, 2018, about socioeconomic group classification based on user features. Another click, please. This is from the patent application. And you can see, again, an attempt to classify people based on socioeconomic status. And another click. And also in August, the Washington Post reported that Facebook is giving users a reputation score, rating them on their trustworthiness. Now, in all fairness, I must note here that it's not trustworthiness overall. It's specifically about fake news and dissemination of information, but we all get the overarching pattern here. Click. Okay, so let's talk a little bit about the implications of trade secrecy in this context. Click. We need to remember first that credit models and credit scoring formulas were traditionally opaque. Frank Pasquale wrote a whole book about the black box society describing exactly that. And they were traditionally opaque, and what we see today is maybe another layer of opaqueness with black box limitations. And also, another click. Interestingly, we see a lot of patents in this area, and in the patents we see that we have some disclosure of information, but they are intentionally very vague. So we can't learn a lot from the patent applications. Just think about the part I showed you about Facebook and the loans. But interestingly, I had the opportunity to speak to some startup founders in this field, and I asked them if they disclose any type of information that they guard as trade secrets outside the company. And investors is one place where such disclosure is taking place. They do disclose a lot of technical details and parts that they will guard as trade secrets to their investors under NDAs. Now, the transparency and accountability aspect is not new. Most of you here in the room know about it and wrote about it. I think one angle that I would like to add to it is the backdoor access via proxies, because in this context of credit, we have regulations in place today. For example, for information that should not be considered as part of the credit score process, as part of the underwriting process. For example, medical information. It doesn't matter if you're dying. This information should not be part of your credit score. And yet, because we have all these alternative models that use big data, the Big Data Act brings in proxies that bring this medical information through the back door. I don't need to ask you if you're healthy. It's enough that I can see that you visited a doctor a lot recently, or that you were looking for specific information on Google, for me to be able to indicate that there might be some problem here. Okay, with that I'll finish up. Thank you. Look forward to the discussion.
Thanks. Oh, super. Hi, everyone. My name is Ari Waldman. I am a professor at New York Law School, and I am lucky to go last because I have the benefit of a presentation really slapped together. And this is very early. I'm going to talk very quickly about some very early research. But this is research based on ongoing ethnographic study in which where I'm interviewing many engineers and also many lawyers and privacy professionals on the ground as part of a multi-stage project on how privacy gets implemented in real life. So I have a particular interest in social robots. I'm a law professor, but I'm also a sociologist. So I'm going to particularly talk about this one area. Then I'll tell you, and I'll talk a little bit in a second about what social robots are, and as well as how they relate to the GDPR. I'll note off the bat that when we're talking about trade secrecy and algorithms, there's definitely other scholars that you should read. In particular, I would direct your attention to Margot Kaminsky's new essay coming out in the Berkeley Journal of Law and Technology called Right to Explanation Explained. When we're thinking about transparency and how we get to the details of how algorithmic systems work, Margot has a really great piece. We've debated it quite a bit about how the general data protection regulation really encourages or gives individuals robust protections to be informed about how algorithms are affecting their lives. I'm not going to talk specifically about that, but I will talk a little bit about the GDPR. So first, So before we get to this picture, I'll just tell you my argument first. I want to take the next 10 minutes to really argue one thing, and that is that this idea of privacy by design, which I will explain in a minute, which some lawyers on the ground think is a direct challenge to trade secrecy, is no more of a challenge to trade secrecy than products liability doctrine. So what I want to do for the next few minutes, I'll explain what a social robot is. I'll show you some examples. I will explain what privacy by design is, and we'll talk about some examples. And then I'll tell you a little bit about my research on the ground and how I think that this is not why privacy by design and traditional protections for trade secrecy for technology companies is not really a problem, and how we can have a robust privacy by design protection for individuals without butting up against trade secrecy. So first, what is a social robot? Social robots are automated systems. They are robotic, humanoid robots that are meant to interact emotionally with humans. And they could be really helpful. And I'll take Glenn's organization of first starting with the sunshine and then get to the cloud. So first, social robots can help children and have been used already in hospitals and in doctors' offices to help children who are scared of hospitals or doctors. They're adorable, and they're often the size of children, and they help acclimate children to a scary situation. They could also be, another one. Oh, great. They could also be used to help children. The second picture is, they can also be, before that. I don't know. So we can stop there. They can also be used to help children with autism. They're actually being deployed quite well and quite frequently now in private schools, charter schools, and even in some public schools to help children relate to other people. And it's hard for children to relate to other children, so social robots allow them to practice social interaction. For children who are on the spectrum, it's actually quite hard. This gives them an opportunity to practice and then be far more calm and far more able to deal with social interaction among other children. Another slide. The previous one, this is a famous social robot, and it's incredibly adorable. It's a baby seal, and there are very few animals in the world where a baby version is as cute as a baby version of a seal. Paro is a social robot that is meant to interact with the elderly and people particularly who are lonely to provide them with social support. So if you go to the next slide, you will see that, and there are a lot of these pictures on the internet. This is Paro being deployed in a nursing home. I believe this picture is from Massachusetts, being deployed in a nursing home. And if anyone has elderly parents, they know that if I don't call my parents enough, but especially grandparents and elderly patients who are in nursing homes often feel quite lonely, and these baby seals offer companionship. And I use this picture to highlight how social robots work. They're not just cute stuffed animals. They react and emotionally respond to how their human reacts as well. So here someone is petting the social robot, and after a while it goes to sleep. And this creates calmness, it creates a sense of belonging, it creates a sense that someone is there listening to me and someone wants to be with me. This is all AI-based. Social robots respond emotionally to their humans by learning, by integrating human behavior into an algorithm that their designers created in order to respond perfectly. So sleeping is one of them. They also respond with words and phrases, and also make people and talk to them in ways that make them respond. If they feel, if the algorithm identifies through various factors that their human is feeling sad, then they may respond with a joke, or they may respond with just "I love you" or something like that. If they find that their human actually is sick or is choking or is exhibiting evidence of some illness that they have, the baby seal is actually trained by a learning algorithm to respond in that way. So next slide, please. So what people don't realize, though, is that's all the sunshine. But behind the adorable baby seal is code, is a technology company that is gathering data and gathering a whole lot of data. This is data about our basic sense of humanness. It's how we act when we're sad, what we do when we're sad, how we respond when we're lonely. And they're also gathering data, not just gathering data that is very essential to who we are, but gathering data about us when we are particularly vulnerable, when we're lonely, for elderly patients when they're feeling sick or we're feeling sad. Next slide, please. So I'm going to leave this up for a minute because I think the world needs more baby seals in the world. This is actually a real baby seal, but I just think it's super adorable. So in my research, what is the problem with social robots? They seem amazing, but in a world where algorithms are unknown, the people who are using these technologies they see this. They see the adorable baby seal. They don't see the technology company behind it. And my colleague out at DePaul Business School has done quantitative research on this, showing that people are far more willing to share information and disclose information to robots and tools like this when they are at their most vulnerable, when they need pro-social behaviors or pro-social encounters. So these robots are AI-generated machines that are there when we are at greatest risk of being manipulated. So enter in the FTC, I think. The Federal Trade Commission here in the United States is our de facto privacy regulator. They deal with a lot of what these call Wizard of Oz setups. That's not a joke, that's a real term. Wizard of Oz setup is a tool that seems like it's one thing when you interact with it or use it, but there's a man behind the curtain pulling the strings. The FTC, I think, should regulate these for their manipulative content, for their manipulative capacity, especially because there's no website here for people to click yes or no on a privacy policy if elderly persons or children with autism or their parents could ever understand what those disclosures mean. One particularly effective way, I think, to regulate the manipulative capacity of social robots is through privacy by design. Next slide, please. So what is privacy by design? Privacy by design is this idea that we should be considering privacy and safety from the ground up, as opposed to something tacked on at the end of the process. And this isn't just an idea, this is the law. This is Article 25 of the GDPR. It's been endorsed by the Federal Trade Commission, and they're starting to issue consent decrees that include privacy by design requirements. And it's also been endorsed by the California Attorney General's office. There is, however, no one single definition of what privacy by design means. You can imagine a very lax regulator at the FTC coming up with a very different definition than, say, a regulator at a DPA in Paris. The GDPR itself has a kind of vapid, meaningless definition for this in Article 25. All it says, if you take out some of the icing on the cake, all it says is that privacy by design means taking technological and organizational steps to implement the other requirements of the GDPR. and which suggests that they meant it as kind of a catch-all provision. But I think privacy by design can be far more robust and more powerful. I wrote an article that's coming out in the UC Irvine Law Review where I suggest that privacy by design, what it really is supposed to mean based on Article 29 Working Party and based on other advice documents, is that this is really a form of products liability. Products liability today, for products liability for design defects, requires companies to engage in a balancing test between benefits and harms, and to provide extensive notice and also changes to design when there are safer designs that are out there that can provide the same type of efficacy and efficiency in the product. And I think that we could apply the lesson to what a statute of privacy by design should look like. So, and I can get into that a little bit more if there are questions on the Q&A, but what does this have anything to do with trade secrets? So in the last 2 years, I've talked a lot to lawyers and privacy professionals on the ground, talking a lot about how they're going to implement something like privacy by design. There's a whole group of people that have no clue, that have no idea what this is, and I think that's one of the reasons why we need more robust and more clarity on privacy by design. But some people have made the argument that the idea that a government is going to require companies to adapt their technology, adapt their design, adapt their code to be privacy protected from the ground up would require an invasion of their trade secrecy rights. Because if the FTC or a data protection authority is ever going to put meat on the bones of privacy by design, they're going to have to audit designs. They're going to have to say, well, something went wrong. Did you actually do privacy by design? Well, in order to check up on that, I want to see your code. Or if the GDPR ever lets individuals, or regulators allow individuals or states to manifest or protect their privacy by design rights, whatever that will mean, then someone is going to have to look at someone's code to see if there were privacy protections taken and if they were embedded into code. At a minimum, it would require people to look at the process by which a product was designed, which companies also protect through trade secrecy. The proprietary processes, the proprietary conversations that they use in order to design something. And I think that argument is just wrong. I think it's a pretext to just push back on any type of regulation, this kind of hegemony of innovation. People will say that, well, if you invade my trade secrecy, if you force me to reveal my processes and my code, then it's going to stifle innovation. I think that's a baseless argument. And one of the reasons is, if you think about privacy by design, can we go to the next slide for a second? I just wanted to put that back up there. If we think about privacy by design in its most robust way, i.e. as a form of products liability for design defects, well, has products liability for design defects ever been considered an invasion or an affront to trade secrecy? Absolutely not. Because what products liability does is it creates norms and it creates rules that companies adapt to and create their products using those adaptations. Products liability has never cared exactly how a car company developed a new seatbelt or exactly what the proprietary ways a company integrated a computer technology into their device or integrated a computer technology into their car, or the way they made brakes better. No one has ever tried to use products liability to unearth proprietary design techniques. So even this robust form of privacy by design would not unearth or force companies to reveal their proprietary secrets, but what it would do is it would create a boundary, limitations on where companies are designing. It would provide a world, a constraining effect on companies' ability to just design things that are only in their data collection interests, as opposed to the actual positive benefits that society and individuals who use social robots can benefit from. So with that, thank you. And if I can ask the other members of the panel to come back up, we have, how much time left since I'm not sure? Okay, great. So we're going to start, I think, with one question from me, and then we'll go to audience questions. So my first question is for Glenn. Since you've had the longest break. So you talked about one of the options that we have to think about in the healthcare space is consent. And this was, admittedly, consent is one part of a whole slew of proposals. And I'm concerned about that. I want to push back on that. And Yafid, I also want to push back. I also want to think, I would love for you to think about consent in the consumer credit standpoint. And I wonder if we should just consider consent garbage, absolutely garbage, because in the healthcare context, you have someone who is who may be sick, needs this surgery. That sounds like consent under duress. In the consumer credit context, you have someone who needs money. You have someone who needs to actually live their lives, whatever kind of, with some sort of flow of capital, and they're going to see there's always some desperate need for money over and above what would protect them from predatory behavior. And we know people are incapable of balancing potential future risks against current benefits. So is consent salvageable in any of these contexts?
So just to frame it slightly differently, two frames. One, if the claim was consent is the panacea that solves all the problems, I would completely agree with you.
Yeah.
The question is whether consent is worthwhile. Everybody agrees that's not going to solve all the problems. Is it worthwhile to require informed consent? And I put it that way because I want to underline the idea of informed, right? The mere fact of having to communicate information, just as in all of our relationships, does have some disciplining and some effects on our behavior, even if we are sure that the other party who receives the offer will always accept it, right? So there's a way in which you might think that actually informed consent, if you had a very strong concept of informed consent, and I'm not sure I do, you might think that in order to truly give informed consent to medicine that is directed in part by AI, you'd need to know a lot about the AI in order to do that. And if it's a legal requirement that you inform the patient, that might force a certain amount of disclosure. Now, I actually don't believe that that is what the doctrine of informed consent does or what it should do, but it may get us part of the way there in a way that frustrates those who want to keep trade secrecy secret.
I totally agree. I think that we have this problem with privacy as well, and we keep talking about consent and the problems with consent. And obviously, we don't have an answer. We don't have an answer because of the information overload, because people cannot process all the information, even if they had it, which they don't. But I think, on the other hand, the reason why we still use consent is paternalism and the fact that we still want to allow people to choose their own choices and to practice autonomy. So I guess the sweet spot is a difficult one to find.
I have more questions, but if anyone in the audience has a question, please just line up at the microphone. I want to give the audience sufficient time to ask questions. Although I have all the questions about your presentations, which were fabulous, by the way. Yes, thank you. Just tell us who you are.
Oh, sure. My name is Dustin. I'm a master's student at the Center for Data Science, so I guess I'm directly enabling all this madness, so I apologize.
Sunshine, too.
Yeah. Well, actually, that was part of my question. Like, I am sympathetic to the whole, explainability and consent issues, but, when you're talking about developing like the latest cutting edge applications for life-saving applications, like for healthcare, what have you, a lot of these models are very sophisticated, very complicated, and sort of difficult to explain in a way that's satisfying or, would make sense to the average person. So kind of where do you draw that line, and do you actually stop people from doing that?
Yeah, so I'm working on a paper now that's kind of a normative account of the right to explanation. So I'm working on it, which means I haven't quite thought it out. But if you were designing a right to explanation, forget about what GDPR, what Margaret says, what other people disagree about what it actually requires. What kind of a right of explanation would you want? First thing I'd want to know is that the distribution of outcomes is better, all things considered, for the whole population than it is under the status quo. So there's some comparative idea. Second thing I'd want to know is that there's no identifiable facts about me that might be connected to suspect classification that would have me worried. Those would be kind of the bare minimum. Those are things that can be communicated to patients in a way that is understandable. Beyond that, there's a lot of other things I might want to know or might not want to know. And one thing to think about here is consent and informing is one of a series of interchangeable technologies of governance. So you could imagine that if you had a steering committee made up of patients that are required as part of the procuring part of it to sign off on it, to those groups of people who could be trained, there could be a much more sophisticated disclosure to them that would substitute to some extent for information overload to the individual patient. So we might think about where patients get involved in governance, Doesn't necessarily have to be at the level of the individual patient. There may be other levels and organizations we could use.
All right, cool. Oh.
I'll just note quickly that I think a question that also came up in the previous panel is which one is better, the algorithmic decision-making or the human decision-making? And I think I never understood this question because even if the algorithmic decision-making is better on certain terms, maybe this is our opportunity to move forward on explanation and on values that we care about. Just wanted to point that out.
All right, thank you.
Yeah, thank you.
I'm wondering how we figure out.
Oh no.
Not that short mic stand. I'm wondering how we figure out when explainability is needed, and by when I don't mean kind of for in what circumstances. I mean like actually when in the decision-making process, and how do we figure out which situations we need explainability, like at the point of care, like hey, I'm going to recommend this decision for you, doctor, and here's why, versus kind of after the fact auditing. Appeals sorts of issues. Like, how do we know which one of those matters? And do you have a sense as to kind of what circumstances one might matter over the other?
So two responses to that. One, first, how does the GDPR do it? Because the GDPR has a right to explanation or a right to be informed. And the answer to that is, well, they don't really do it. It says people have the right to be informed, and then if you add that into other articles in the GDPR as well as some recitals, it suggests that you have a right to be informed when something is when the use of a data collection tool is implicating your personal information. The personal information definition of GDPR is broader than what we have here, but it also may not accommodate some of those correlations or that information correlations that Glenn and Yafit were talking about Instagram filters as well as capital letters and stuff and things like that. So given the inability of the GDPR to specify these kind of things and the fast-changing way in which seemingly non-personal information could lead to personal information, that we don't have a good answer. My view, especially given my work on privacy by design, suggests that we should be informed that regulators should have an opportunity to be informed during the design process. That the privacy by design means allowing regulators to see how privacy is or is not being integrated. And then, like products liability, users have an opportunity to be informed at the moment that thing leaves the warehouse, but also ongoing. Because products liability requires companies to say that if they find a weakness, a design weakness that could cause harm, that they have to inform their users. That sometimes leads to recalls. But with technology, it's so much easier. You just push an update. So there are far easier ways to continue that information during use.
I might just want to add that we don't have to go crazy here in the sense of the following way. There's plenty of places currently where things are explained to us or not explained to us at various levels, and we can look to analogs. When your physician recommends a course of treatment, there are questions you ask them, but you don't ask them exactly which journals did you read last week, what did your other colleagues respond, right? There's a lot of information. When FDA approves a product, there are things that are disclosed to them that are not disclosed to the end user, the results of all the clinical trial data, right? So in my mind, what we should be doing is adapting the existing choice points for explanation to algorithms rather than thinking we have to start from scratch with a new idea of what explainability requires.
Oh, hi, thanks for the great talk. I'm Brian, I'm an LLM student, and you answered a third of my questions, but I was still wondering, or just points of clarifications, I guess, in terms of first little hedge back to Mr. Jason Chu's presentation when he talked about true transparency, and I feel like it kind of loops back into the current discussion in terms of consent and the technicalities we get into with what's informed consent and all that, the various levels. So I guess my remaining question would be, what is true transparency in all this, and what would be acceptable consent? Like, what would be the base level we'd be working with in this to make it work for everyone? And if you could loop that back into GDPR again, that would be great as well. Thank you.
Great. Does anyone else want to add about consent?
You can start.
So what would ideal voluntary, free and voluntary consent look like in this context? I have to admit, I am very skeptical that any form of consent is actually viable and free and voluntary. Danielle Citron and I are working on a paper. Oh, first let me talk about other people. Neil Richards and Woody Hartzog are publishing a paper on this myth of consent, and they're showing how we have continually relied on consent in the data space, essentially too much, and they talk about all the harms associated with it. Danielle and I are adding to that by arguing that consent actually operates in the exact opposite way in the data or in the AI context than it does in any other context. Because in, say, the sexual consent context, the whole point of consent there is to stop behavior that the consenter feels is somehow invasive or harmful or just bad. In the data and the AI context, consent operates as a license. It's as soon as you allow, when the company gets you to toggle that button from gray to green on an iPhone, then it's like, yeah, let me do whatever I want with this data because I have your consent. So that operates that way partly because of the technology, partly because of the nature of the information, the nature of the kind of information that we're gathering, and also because of the manipulative asymmetrical power that these companies have. So I have to admit, I am not sure that there is any adequate level of consent or a form of consent that would be free and voluntary in the data context.
I want to push back on this distinction, and
please,
maybe this
please.
reflects more about our sex lives and everything else, and that I think that sexual consent also opens up the possibility for experimentation, for new experiences, and for things that are unexpected, right? So I don't view it as merely licensed to do the one particular thing we've talked about, but it opens up a kind of relationship that's new. And maybe it's the case that we love, or when we love, maybe not love, we have some affection for our sexual partners in a way that we have zero affection for the lender, Google, or Facebook, such that we view this as kind of a highly legalized and ritualized form of consent, rather than the idea of an opening bid that starts off a relationship. So I would be interested to think about, could we make the informed consent for data setting more like the meaningful consent to marriage, that kind of relationship, or consent to other kinds of relationships?
Interesting.
I agree, and I also think that we need to seriously think about migrating the concept of consent from human to human interaction to human and machine interaction, because people think and act and behave completely differently. Just like you mentioned about the disclosure of information to robots when you are in a vulnerable situation. You feel more comfortable sharing information with robots than with humans. So I think some of the norms and way of thinking that we kind of bring in from our understanding of the world in human-to-human interactions, just not the same when we have human-machine interactions.
We're going to keep our answers short so we can get good questions.
Sure. Hi, I'm Ashley. I'm a fellow here at ILI, and my question's for Glenn. I was struck at the beginning of your presentation by the language of democracy and democratizing this technology, because for me, part of it is taking away people's jobs. And I understand democracy is about having a kind of say in what goes on in the world, and a lot of these people will have no say when they lose their jobs. So is that part of our consideration also, how the automation also will be eliminating a lot of jobs, and people won't have say in it, and particularly people that took on a lot of debt to get those jobs?
Great question, and I love this kind of fraught ambivalence about democratizing. So I was using the term to think about who has access to expertise, right? But you're right, the democratization of expertise might cause losing some of the jobs of the experts. Now, what I think is very interesting about the medical context is typically when we're talking about automation, we're picturing factory workers and people who are kind of lower skilled and who life has dealt not the best hand, always losing their jobs. And what's interesting about the medical AI world is the kind of people you're thinking are the dermatologists now and the radiologists. Now, this goes to just a broader question about medical migration and medical personnel. We already have way too many specialists as to primary care doctors in terms of what we're generating in the future. So a world where, as a result of AI, we have fewer people from medical school going into dermatology and more going to primary care doesn't strike me as that bad. But I can see in other contexts why it's more threatening.
Thank you.
Thank you.
So this question's for Yafit. So one thing that I find interesting in the financial context is that the people who are developing these programs actually have an incentive to make sure they're actually working correctly, as opposed to some of the ones we talked about before where, you know, you throw this guy in jail or that guy in jail, the developer doesn't care. So I'm wondering if there's anything that we can learn from the way that these things are, the way they're sort of self-accountable, what the financial companies do to make sure that checking for how often you do selfies actually tells you something about your financial risk.
First, we need to ask what is accuracy and how do you measure accuracy. But I think it goes to the heart of the accuracy fairness trade-off that we talk a lot about in this kind of debate. So yes, they consider a lot of information and they take into consideration a lot of information. But and maybe the result is accurate. But do we want this result if it includes?
No, but I'm asking, how do they do it? I mean, can we learn from how they actually check their own machines, things that would help us think about how to check other ones?
In terms of the accuracy, I'll need to think about it more. But I think it's. First, I think there is still debate as to how accurate these tools actually are, and they have the privilege of choosing their applicants very wisely. They don't have to take anyone. So I think to begin with, it's an easy setting to work with, but I need to think more about how we could actually take ideas from there. But it's a good question.
There are so many opportunities, so many more questions that can come up. However, I'm being given the hook. So for those who are still in line, perhaps we can all, perhaps we can all talk at the break, or I certainly don't want to keep you from lunch, which I believe is what's pending for us. So thank you so much.
Thank you.
Thank you.